On behalf of the Patient Safety Authority, I'd like to welcome you to this webinar titled Warning Fatigue, Now a Matter of Criminal Liability, the RaDonda Vaught Story. My name is Kelly Gibson, and I'll be your moderator for this program. Now I'd like to introduce our speaker for this webinar. Matthew Keris is an attorney at Marshall, Dennehy, Warner, Coleman, and Coggin. He has defended doctors, health systems, long-term care providers, and medical device manufacturers for more than 2 decades. He is a shareholder in the firm's healthcare department and chair of the Electronic Medical Record and Audit Trail Practice Group. Matt has developed substantial expertise in electronic medical record, EMR, preservation, production, and discovery matters, having authored a book on the subject, Electronic Medical Records and Litigation, for Thomson Reuters. With a primary focus on assisting clients with legal matters related to EMR issues, Matt also provides consulting services on a national basis to attorneys grappling with EMR and audit trail discovery issues. In this capacity, he is brought in as a legal consultant to provide guidance on managing this unique aspect of litigation. Matt serves as a resource for clients in the legal community on issues pertaining to EMR, and his commentary is routinely sought by legal publications, including the Legal Intelligencer, Law 360, ED Legal Letter, Risk Review, Litigation Management, Counterpoint, and Becker's Hospital Review. Matt also serves as an editor of Patient Safety, a journal published by the Patient Safety Authority. Matt, I will now turn the program over to you.
Thank you, and thank you all who are listening in here today and participating for giving me some of your time in these busy, unusual times. I really appreciate that. As you know, we're here today to talk about a phenomenon, if you will, dealing with electronic medical records, and that deals with what I call warning fatigue. Some other people call workarounds, but it's some of the using a real-life example of a nurse in Tennessee, using her situation as an example to help educate you as to some of these issues that you'll probably be seeing in you can probably see at your institution, or you may see in the context of a civil case later on. And as I mentioned, these are unusual times. I think that for institutions or portions of the institutions that are very busy, where people are being called in to work in certain departments like the emergency department with COVID, with the ICUs, you're going to see shortcuts. You're going to see people perhaps not being as careful and with certain practices and protocols as they would if things were not quite as busy, because they truly have been busy in these last 3 months. You'll see more and more, and maybe you'll see it in a year or two down the road, or if you come across it now, where people are using workarounds or are tired of these warning pop-ups or warning screens that they see on the electronic medical record. So I think that this presentation is actually quite timely in that you're hearing about it now, so that perhaps you can mitigate these types of issues from occurring now before they become a problem. Unfortunately, this case is a warning because it's an example of what some people say is the criminalization of negligence. We're going to go through this case factually today, using information and materials primarily through the local newspaper, the Tennessean. This took place in Nashville. The materials you have all come from public sources. There's nothing I've learned that's been confidential. I've not spoken to anybody who's involved in this. This presentation primarily comes from media reports and public documents that have been published through the media outlets in Tennessee to show you how this situation with Ms. Vaught is ripe for peril for institutions, nurses, and other places across the country. I'll be perfectly honest with you. Since this presentation has been publicized, I have received at least one call from an attorney in Pennsylvania that is facing a similar circumstance of what we're going to go through here today, where they're facing a criminal inquiry regarding a negative outcome due to a medication administration issue where people are tired or just ignoring these warnings. So if that is what I've heard since this has been published, you know that there's probably been others. There's probably others that are going to be considered. And as you'll see, if this Vaught story goes through and has a criminal trial, you'll probably see more national press on it, and you might see other law enforcement officials do similar investigations in our jurisdiction and other jurisdictions. So this is fraught with real issues here, and how our electronic medical record systems are now, the way they're set up and how we're teaching nurses how to use them, are setting them up for possible criminal liability or criminal scrutiny. And I think that this presentation, and this is an example that we can all take back and perhaps rethink how we document our medication, how we administer our medication, and how we set up these electronic medical records systems as a whole, because like anything, there's always room for improvement. But we're going to use this case and a couple other sources as examples of how these pop-ups, et cetera, could be hurting our care and could potentially be impacting our systems. With following up with, obviously, I handle malpractice cases, how if a case like this is prosecuted criminally, how it can impact the civil case that comes thereafter. So without further delay, I'm just clicking through some of the slides to get here. You see the objectives that are we'd like to get through today. And we are going to go through approximately 50 minutes total of lecture, if you will, and we will handle question and answer during the last 10 minutes. So please feel free to, if you have a question, to submit it. We'll handle it over the phone in the last 10 minutes, and I'll be happy to go over the 1 hour allotment if there's that many questions. So anyway, using the slide before you has some pictures of RaDonda Vaught, and giving you examples of how this situation has been portrayed by the media. It's been all over the news in Tennessee. You see some of the medications that are involved in this matter, and there's actually a GoFundMe page that has been established to pay her legal defense costs in this matter. That's actually been a sounding board for a lot of nurses on how they're dealing with electronic medical record systems and the issue of workarounds. It's quite interesting just to stop by and take a look and see what people are commenting about. But this situation has drawn national publicity, including a article or a presentation on NPR radio and about the criminalization of potential criminalization of negligence in malpractice cases. So just to get everybody on the same page, what exactly occurred? So the events that we're going to primarily discuss occurred on December 26, 2017, going on 3 years ago. The patient's name was Charlene Murphy. She was in the hospital with a suspected brain bleed and a PET scan was ordered. She had, and it's been reported that she had anxiety associated with going in for this imaging study, like so many of the hundreds, if not thousands of patients, well, thousands of patients across the country. It's pretty routine for Versed to be ordered by the physician to treat patients with anxiety and undergoing these imaging studies. So pretty, at any given hospital, this can be happening right now. Probably several of these instances have occurred today or even this week. Fairly routine set of circumstances. What do we know about Ms. Vaught? Well, she's 35 years old. Meaning she's been a nurse for quite some time. She's not a rookie. She's not green, if you will. There were no disciplinary issues reported. There's no licensing issues associated with her. So for the most part, she's considered a good nurse. no real red flags going on there. She was competent. We know that this event occurred in the neurologic ICU unit of the hospital. There was not a staffing issue that particular day. We know in retrospect from her that she was not overtired, and that this event occurred as she was orienting a new hire to the department. And moving on to the next slide, you'll see we have, it's entitled Sequence of Events, and the text underneath, it looks a little different. It's not the typical text you'd see on a routine PowerPoint. That's because I pulled this sequence of events from the criminal documents that were filed against her. Again, these are public documents. You could see them, but this is included, and I think it's useful to see it in this form to show you the level of scrutiny and actually to break down how specific their investigation was. And these set of facts are not for the meek. I will say at the outset, as a person who's been doing this for 20 years, I'm one of the biggest advocates for nurses that you'll find. My mom is a retired nurse. My father is a retired nurse anesthetist. Nurses are near and dear to my heart. But as you go through this, like me, I think you're going to be a little shaken in terms of what exactly occurred. So what we know is that Vaught pulled up the patient profile in the Accudos system, and she could not find the Versed prescribed by the doctor and reviewed or approved by the pharmacy. So she knew that Versed needed to be given, but she did not contact the pharmacy to confirm the medication order, and she decided to administer the Versed by overriding the system. So she begins the override, and as she begins the override, a first pop-up appears, and you'll see it, the override, the text is in quotes within the materials there. Override medications should only be accompanied by stat order or when the clinical status of the patient would be significantly compromised by the delay that would result in a pharmacist's review. So that pops up. That comes up. She puts in the letters VE, hoping it or thinking Versed would come up. Unfortunately, vecuronium bromide came up on the search. And very briefly, vecuronium bromide is a paralyzing agent, typically has to be given to patients on ventilators, and in some states is used as the lethal injection for criminal people who are sentenced to death. It just paralyzes the lungs. So that comes up. Vecuronium bromide comes up instead of Versed. So we have the first pop-up comes up. A second pop-up shows up after she puts VE in. It prompts the user with a pop-up screen asking for the reason for the override with several justifications such as urgently needed, such delay might cause the patient harm, the prescriber is physically present and can oversee administration, and it clearly states on the screen that this is a paralyzing agent at the top of the list. And there must be a reason why this override should be enacted, but it's right there. The second warning says it's a paralyzing agent. Obviously, Versed is not a paralyzing agent. She blows through that warning, which takes her to the third warning, where it says vecuronium bromide on the screen with the notation paralyzing agent. And despite these three warnings, she pops through it again and gets to the fourth warning on the screen. Another pop-up screen appears showing an alert that once the vecuronium bromide is selected, again it warns that it's a paralyzing agent and the medication causes respiratory arrest and the patient must be ventilated. And then the user must press another prompt to remove this warning, which Vaught does. Fifth warning. User is asked to select the quantity of the drug at the top of the screen, and another warning comes up for paralyzing agent with a yellow caution sign highlighted alert on the screen. So 5 pop-ups come up, mostly the same thing, but these are all EMR pop-ups that she blows through to try to get the patient what she believes to be Versed. So those are the computer red flags, if you will. But then there are several clinical red flags that appeared thereafter, which unfortunately Ms. Vaught ignored as well. And this you'll see on the screen, you'll see the top of the medication there. This is from the criminal file that's public. That was the top of the bottle of the vecuronium bromide. That's what she would have seen. Also, vecuronium bromide comes in a powder form as opposed to liquid. And these are two things, again, that Ms. Vaught either chose to ignore or negligently ignored in providing the vecuronium bromide to the patient ultimately. After those two clinical red flags appear, she would have to read the instructions on the bottle to reconstitute it, and despite the fact it said vecuronium bromide and not Versed, she continued. She would have shaken the bottle to reconstitute the medication, which is something you don't typically do for Versed. And then she'd have to look again. We saw the red cap bottle on the page before. She'd have to see that, put the syringe in there to draw it, and still she continued. So in addition to the 5 electronic medical record pop-ups, now you have what the law enforcement called 5 red flag warnings. And there's, again, this is from the public portion of the criminal file. This is the bottle, and if you see to your left, pretty broad terms in big capitalized and bolded letters, vecuronium bromide, and then there's the warning that's on the back to the right. Not a great picture, but that's what we pulled online. So she does all that. Vaught is then informed that the staff in the PET could not administer the medication because they were running scans, and that they could not monitor the patient after the medication was administered. So she administered the medication herself, and contrary to policy of the hospital, she immediately left the patient alone in the PET on a mobile bed. That's critical that the patient was left alone, because if someone would have stayed with her, the possibility existed that the respiratory arrest that she was undergoing would have been picked up in time, in a timely manner, and something could have been done to avoid what ultimately occurred. And as the complaint, this is still part of the criminal complaint, the victim would have shown signs of acute vecuronium intoxication, which would have caused paralysis, respiratory failure within minutes after the drug was administered. And since Vaught did not follow the mandated observation protocol, the victim was left unattended when shown signs of onset of respiratory failure. So here's this poor woman in the PET scan, obviously anxious before she even got there. That's why they asked for the Versed to be administered, who is there, is conscious, and knows that she can't breathe. And unfortunately, she passes away the next day. She is coded, and they try to resuscitate her, but it doesn't work well. She passes away the next day. So the next screen has, again, a Tennessee Bureau of Investigation report. At some point later, I'm kind of jumping the gun a little bit, but the next several slides deal with the interview that Ms. Vaught had with law enforcement sometime thereafter. And it jumps around in the timeline a little bit, but I thought it would be appropriate just so you would know firsthand what she was thinking at the time, based on this interview. So on December 5th, 2018, a few months, long after this occurred, moving on to the next slide, this is the criminal report about the investigation. Vaught looked back at the vial and saw it needed to be reconstituted, but never looked at the front of the vial. And again, this is a public record, and I bring this up because we'll get to this later on. This would be considered gospel truth, essentially, in the civil suit that would follow. She went down with Darren. Darren is who she was educating that day, the new hire. She went with Darren to the PET scan unit and found Murphy. She verbally verified who Murphy was, but not. This is another issue. She could not find the computer to scan the medication. She reconstituted the vial, gave Murphy 1 milligram, and left her with the PET scan unit tech. After administering the medication, she never scanned the medication into the medical record, which, although the law enforcement don't list that as a red flag, but that's yet another opportunity, if she had in fact scanned the medication after administering it, that she could have caught on that she was giving the wrong medication. She chose not to because she could not find the scanner. So scanning is another protocol that she did not comply with during this course of events that plays a role in why law enforcement decided to prosecute her criminally. So after the code was called, Murphy was brought to the neurologic ICU from the PET scan unit. Vaught informed the 2 neurologists, Drs. Neely and Trantham, and the acute nurse practitioner, that she did give the vecuronium bromide, and she was so sorry. She claims that a unit manager advised her to not to scan the medication because the MAR would note it. She admitted she had administered Versed before, but never vecuronium bromide. She admitted being distracted by talking to Darren about the swallow study they were going to do. And I want to just highlight she was distracted because that's going to be relevant to where we're going to be speaking, or where we're going to be speaking to in a couple of moments. She admitted she shouldn't have been distracted with something other than the meds at the time of dispensing. She admitted she shouldn't have overrode the system, although it is common to do so. So that's, for those of you participating today, this is a common thing. I think you all probably are aware of something similar to this, but it's common to override. She admitted it struck her as a little odd that she needed to reconstitute what she thought was Versed. So she admitted even knowing that was an issue, but she didn't catch on about the error. And she didn't recall anything on the vial to alert her, but she said she would have recognized the difference. But we know that she did not really look at the vial because it says it in bright red letters at the top of the bottle. It's a paralyzing agent. So despite all these safeguards that we set up for her not to fail, they failed her. Moving on to the next slide. She admitted again she was distracted. She should have paid attention and shouldn't have overrode the medication because it wasn't an emergency. She said she should have called the pharmacy to check on the status on the order of Versed, and she admitted that right after she probably just killed a patient. And what did I do to this patient to kill her? What kind of life-changing things did I just put this patient and family through? It's a horrible situation, in quotes. And I'm not going to repeat her last note there, but obviously I don't think there's going to be anyone who really disputes that. So all of that was all that information I've gone to for approximately the last 12 or 10 slides are all public records. Anyone can pull them up. I did, and that's what happened. So essentially, there's your discovery in a medical malpractice case in 12 slides or less. Some other facts, that day, and it's been part of the reason why this case has garnered some of the attention in Tennessee is there was some curious events that occurred thereafter, and this is a summary of that. 2 neurologists reported Murphy's death to the Davidson County Medical Examiner that day without mentioning the medication error or the use of vecuronium bromide. Her death certificate at that time deemed her death natural due to bleeding in the brain, and the medical examiner of the county was not independently involved to investigate the death immediately thereafter. However, you'll see approximately a week after this occurred, Vaught was terminated, and the hospital reported the error to no one, none of the local state agencies, no one at all. It was not reported, and some would argue that they had an obligation to report, but it was never reported. However, and I've only discovered this recently, again from reading the local newspapers, that the civil claim was settled with a confidentiality provision shortly thereafter in the first part of 2018. What is interesting is if you go back and read real-time some of the news articles, the son of Ms. Murphy was interviewed and stated he was not interested in any type of settlement. It wasn't the way the family was morally, how they were raised, that they didn't think two wrongs make a right. They didn't want to pursue anything. Their mother would forgive them. So the statute of limitations had expired in Tennessee in 1.5 years. When this all really came to light, essentially the statute of limitations had expired. And I was really shocked that there wasn't any type of civil claim. But as it turns out, there was a settlement procured, and it only, again, with the confidentiality provision, which is typical in Pennsylvania, that all settlements have a confidentiality provision. So I can understand why the son answered questions about the other, about a lawsuit the way he did. He was complying with the confidentiality provision. But this really came to a head in October of 2018 when an anonymous complaint was filed with CMS, and thereafter, things started moving. And this is a good several months thereafter, about 10 months thereafter. The Department of Health in Tennessee investigated this, and again, we don't know the rationale or the thought process. They initially cleared her, saying she did not commit any type of malpractice or negligence, and there was no reason to pursue her license any further. And that was in October. But I think due to the reporting and some of the publicity this matter got in September, approximately a year later of 2019, without an explanation, the Department of Health reversed their decision and charged her with unprofessional conduct, abandoning or neglecting a patient that required care, and failing to maintain an accurate patient record. So the Department of Health. In March, and this is why we're here, criminal charges were filed against her, and these are the Tennessee criminal codes, and for the most part, they may be different names or obviously different codes. Pretty much every state, I would argue, would have something similar to this. They charged her with reckless homicide, which key language from that statute was a person consciously disregards a substantial and unjustifiable risk, and abuse of an impaired adult. It's an offense to knowingly, other than by accidental means, neglect any adult. And what they're doing is they're using the pop-ups, the 5 pop-ups, and her essentially admitting that she knew something was up. That is the intent. With most crimes, you need an intent, a criminal intent to do something. Other than like a statutory crime, like you need an intent. And the prosecution is going to use the evidence that she disregarded these pop-ups, these warnings, time and time again, to show that she had the intent or was so negligent it warrants the criminal charges to be filed against her. If this goes horribly wrong for Ms. Vaught, she can spend anywhere between 2 and 12 years in prison plus a fine. Ms. Vaught pled not guilty, and during her preliminary hearing, he said publicly that the hospital shares blame in this. And quite frankly, you've seen the undisputed facts. I don't think we went through the criminal part of this. The facts don't look good for her. So as a lawyer, not a criminal defense lawyer, I think that this is probably one of the only ways she can defend herself is to acknowledge that these pop-ups and the warnings and the workarounds are common in hospital practice and may be a reason why she did what she did. I mean, what else does she have? There was a hearing scheduled for last week about her licensing status. However, I am unaware of any decision, and for all we know with COVID-19, it may have been postponed. However, I do know, and I just checked earlier today, her criminal trial is scheduled for July 13th, 2020. However, like everything, including in Pennsylvania, it's not quite clear if any trials will take place in summer of 2020 due to COVID-19. But she is scheduled for trial on later on this summer in approximately just shy of 2 months, and we talked about the GoFundMe page. So let's talk generally about warning fatigue. For those of you who don't know, it is now recognized as a major and unintended consequence of the EMR and is a potential patient safety hazard. Essentially, our clinicians receive so many warnings, they have become desensitized to the safety alerts and therefore ignore or fail to respond appropriately to such warnings. It's compounded by the fact that a majority of these warnings are clinically inconsequential, which goes to the question, who designed these systems? Was it the tech person or was it the clinician? And perhaps we should, again, my editorialization here, perhaps we need to include our clinicians in the decisions on how to make these systems more than just relying on the tech people. And another issue is how patients perceived, how they're being treated. People, oftentimes, as we know, patients will criticize clinicians for spending too much time on the computer and not them. And they'll ask the question, are you treating me or are you treating the chart? So in a way to get to the patient, people are going through the electronic medical record more quickly. Interesting op-ed piece in the New York Times from September of last year, authored by a Pennsylvanian in Pittsburgh, a nurse. She wrote a nice piece that was well received, saying that the American medical system is one giant workaround. And in this article, she talks about similar things in terms of these pop-ups and warnings and how they're contributing in a negative way to nursing clinical care. A workaround, she essentially in this op-ed piece is defined as an adaptive response to a real or perceived barrier or system flaw. She cites in her piece that workarounds are used to save time and are now prevalent because pharmacy and the administrative bureaucracy of giving meds takes approximately 10% of a nurse's day, about 90 minutes a day average on a 12-hour shift, and it's just too long. She reports that she being aware or having reported to her in some institutions that nurses are stockpiling medicines in ceiling tile, not for diversion purposes, not for their own personal purposes, just so they can get the medications to their patients in a more timely manner and give themselves more time. This piece talked about ECRI and ECRI issuing a report that workarounds are the fourth on a list of top 10 patient safety issues from 2018. And the article talks about the perceived workaround that inequity that nurses, or inequality, I guess is a better word, that nurses are feeling with these pop-ups in the electronic medical record system by the use of the hiring of scribes for physicians. Physicians report burnout because they're stuck with these electronic medical record systems that they don't know, or it just causes them all types of stress, and you have people leaving medicine because of that. So as a response, health systems are hiring scribes, and in 2014 there were 20,000 of them nationally, and it was anticipated that this year there'd be over 100,000 scribes in healthcare in the United States, and how nurses perceive that as it's a workaround. The doctors are being catered to more than the nurses. The nurses don't have scribes. And when nurses claim to be overburdened and want more staff, and they say, we don't have money for more nurses or on the shift, they look at the hiring of these scribes and they say, come on, you're benefiting them, the physicians, and it's perceived as another slight towards their profession in some circles. What's interesting, you go to this piece and read the comments to, there are over 300 or 400 comments to the piece. It's quite interesting. We won't get into it here. She also discussed, and this is a part of the problem with medical administration, is that barcoding. She talked about in this article, barcoding seems great. It can catch errors, but oftentimes medications are being ordered that don't have the barcodes, which is contributing to delay. There's wrong barcodes, which is contributing to delay. The patient wristbands are difficult to scan because they're of the patient positioning, or if they're resting or sleeping, you don't want to disturb them to use. The medications on the screen are hard to read. The scanning system and the EMR systems are not integrated, which also result in double charting. And when you have patients with greater than 20 medications per shift with varying delivery times, it really, really contributes to the delay, and it really contributes to the use of workarounds. Scanners are not being used, or patient barcodes are being attached to medication carts rather than the patients. And she had mentioned how she was aware of, at an institution, they were aware that no one was using the scanning, so they publicly graded the individual nurses on their use of barcodes to shame them into, being nearly 100%. Is that a good idea? I'm not certain. These grades were available to patients and their family members, so just something to consider. The Patient Safety Authority in 2017 did a study, or published a study they did about medication errors attributed to health information technology. And we won't go into great detail about this individual study for timing purposes, but there are a number of recommendations that the Patient Safety Authority made that are applicable to the RaDonda Vaught situation, and I think are worthy of mentioning as before we leave here today. But again, very briefly, in 6 months in 2016, the first 6 months, approximately 900 errors reported. 69% of them reached the patient. Fortunately, less than 1% resulted in patient harm, and 50% of the errors were related to health information technology. And you'll see the breakdown on the barcode, the percentages of the errors for prescribing, transcribing, dispensing, administering, and monitoring. 26 of the reported cases dealt with medication alerts. 21 cases reported multiple alerts. 21 cases did not cause the provider to modify their original order. And in 4 of the cases from 3 different hospitals, the report explicitly mentioned that alerts for prescribers had been disabled by the health system. So the health system disregarded. They formally adopted, I guess, the workaround there. But the strategies that came about from this study that were relevant and could have helped out if they were enacted in the Vaught case. Number one, when there's root cause analysis, make sure you include IT staff so they know what's going on clinically. 2, train your new staff members to ensure they are competent before allowing them to use health information technology for patient care. Again, we didn't necessarily have to train patients or nurses or staff with the paper chart as much as we do now with all these system upgrades, changes to the system. There's an old saying, garbage in, garbage out. If they don't know how to use these systems, you can have a negative consequence and a negative event. So training is important. Identify and eliminate the workarounds, and be sure to inform staff when changes to the system have been made. Again, with COVID-19, in busy portions of the hospital, you can anticipate that workarounds were much more prevalent than before. Other general recommendations would be to use tall man letters on the computer screens to help differentiate look-alike medication names, and avoid displaying look-alike names next to one another in a computer drop-down list, and consider differentiating using look and sound-alike drugs by including their purpose. And the examples are there under hydroxine and hydralazine, how you could help our providers differentiate the two, because they can be similar. They have the HYDR at the beginning, but by putting the big boy or the tall boy letters and the use in brackets, that can help. Now, I mentioned, moving on to the next slide, distraction. RaDonda Vaught was distracted. She was orienting the new hire. Limit with the pharmacy system. Limit distractions to providers when ordering medications or completing their crucial tasks. Twice, Vaught mentioned, or it was twice it was mentioned in that report, how a distracted RaDonda Vaught was in orienting at the same time. Eliminate alerts in the system that are clinically irrelevant to prevent alert fatigue. That's what we're here about. Reevaluating our alerts to avoid redundancies. With the dispenser, they should be located in an area of limited foot traffic where a minimum number of distractions is the norm. The dispensers should be in a pharmacy profile mode. Use of profiled ADC ensures the pharmacist will validate the new medication order in the pharmacy system prior to the medication being accessed by the nurse. Do not allow nurses to select medications by using the inventory mode except in an emergency, and require an independent double check for high alert medications and documentation of rationale for the override. By the way, these recommendations were available prior to these events in Tennessee, and I just went back to show you that. So here we are. We have a criminal trial that's most likely going to receive national attention by the media. It's garnished the attention of nurses nationwide. If you go to the GoFundMe page, people are donating a lot of money to her. Ms. Vaught, most likely will need it to pay for her attorneys. She's in the several thousands of dollars have been raised for her. And this is the first time, at least that I'm aware of, that we have a criminal trial of a nurse. Clearly bad facts, but did her conduct reach to the point where it should be criminal? And I leave your opinions to you. You can argue it either way, but we know for a fact that her criminal defense counsel has stated publicly that he's going to implicate the healthcare system. So as most of you who are attending here today are from the health system perspective or are employed by one, what would that mean to you? And how dangerous would that be to you? And we are in some ways, undocumented waters here or uncharted waters. So the first question I have is, will the hospital be a friend or foe to the nurse? If Ms. Vaught is going to make the hospital a major part of this case, you can bet surely that she may call in hospital administration, IT staff into trial as witnesses or request documentation, looking for evidence that could justify why this occurred. And perhaps she can even retain her own expert or an advocate to testify on her behalf. Maybe the person who wrote the op-ed piece in the New York Times. Maybe they'll cite the Patient Safety Authority Bulletin to argue that this is an acknowledged issue that health systems knew about prior to this effort, or prior to this event, and should have known better and made it easier for her. If I were the defense counsel for her in the criminal case, these are things that I'd be looking for, trying to show the system failed, not the nurse failed. It can be a public relations nightmare for all involved. So if the hospital is going to be a foe towards this nurse, what does that mean for nurse recruitment? Will nurses who are sympathetic to Nurse Vaught knowingly choose not to work for a certain system that handles the case this way? If they're going to treat her this way, how will they treat me? So that's not good for the hospitals. Admissions, it's not good for having patients come in, obviously. And there was the CMS was involved. Medicare reimbursement was threatened to be withheld at this hospital, especially since they learned very late in the game about this investigation, and CMS wanted to know what was going on. But that's not good for the hospital. It's not good for nurses as well, or the patients. The hospital is the biggest loser here. It also raises an interesting question with the offending employee. What do you do with that person similar to Vaught in those circumstances? Do you terminate her like they did? Do you keep her but suspend her with pay and just move her to another area? Do you suspend her without pay? Or do you limit her privileges in some way? There's no right or wrong question, but these are things to consider. The reason why I included other options other than terminate is that once she's terminated, And once there's no longer a relationship, there's no control by the institution over her. And you'll see she can say anything. And if she says or testifies against the hospital in sworn testimony, that could be damaging to the hospital, both from a public relations standpoint as well as if there's a civil case thereafter. If you keep her on the system, you can at least control her to some degree. Again, it's a case-by-case basis. There's not a right or wrong, but it's something to consider. Some facts may absolutely warrant termination. This may be one of them. Again, I don't know all the events. I know enough. I think we all know enough what to do. But that's just something to consider moving forward. How to deal with these employees, with the need to balance discipline and keep the system safe. But you want to have some control or some cooperation ultimately, or you may want that, which you may not get if the former employee is unrepresented or has counsel that's going to be adversarial to the hospital. Just something to think about moving forward. The civil liability implications, like I said several minutes ago, the criminal investigation becomes essentially the blueprint for the civil case. The police reports, the interviews, the documents, they all get into evidence in the civil case, and the testimony will most likely be repeated. It can be used against the institution. It can be used against the nurse. I have cases where there's criminal involvement or criminal investigations involved. I mean, the police reports are turned over. That's what they follow in pursuing the case. And you saw there was a lot of bad information for the hospital. There's a lot of bad information for Ms. Vaught in that case. And you'll note, I don't know if you picked it up, she was unrepresented when she was being interviewed by the police. That's not great. From the civil liability perspective, the question becomes, was she out of her scope of practice in this situation? Because that triggers a lot of interesting questions. If she's out of her scope of practice, there can be a reservation of rights where there'd be a continued duty to defend but not to indemnify. If she was engaged in criminal activity, obviously that's you can never insure for criminal activity, but is what she did criminal or is it negligent? Can you defend her under negligence? Do you want to take her under negligence? But that's something to consider. Some may argue that because if she had a criminal conviction, she's out of her scope of practice. There's no reason to indemnify. From a nurse's perspective, this may incentivize individual nurses to buy their own liability insurance. That's a question that commonly comes up from nurses that I get. We all know, for the most part, hospitals or brick and mortar are sued for the actions of the nurses because they're the deepest pocket and they're covered under the excess policy. But if this is an example of with Ms. Vaught, where she may want her own insurance because even though there's arguments, again, whether it's criminal or negligent, that if there's not going to be a duty to indemnify by the hospital, if they take that position, the individual liability policy would most likely cover this claim. So it may be an argument for a nurse to have their own policies. Again, I tell the nurses that I represent there's no right or wrong, but this is an example of where they may want it. But again, this is an extreme example. Corporate negligence. In Pennsylvania, for those of you who are involved, that corporate negligence is the theory of liability. It's not master servant, that the administration did something wrong. Using the Vaught case as an example, the hospital would face potential criticism for having easy overrides, too many prompts or warnings on their systems that would create the system where they are fatigued, the users are fatigued, especially if Ms. Vaught talks about it's common for them to override the system. There's your evidence that the hospital either knew or should have known that these prompts were being overridden quite commonly, and the hospital failed to do anything about that. It goes back to lack of training. There can be arguments that the hospital failed to train their people how to use these systems accurately or in the best way. There's a general theory of liability in Pennsylvania that the hospital can be liable for failure to create a safe environment. And again, that there can be an allegation that the hospital failed to, if they had the policies on point, but they didn't enforce the policies, there can be criticism that way. So this is another example of how the hospital is the biggest loser in this situation, because they have the deep pocket. These arguments would probably be easy to make by an expert for bad facts. It's not good, and that's why we saw that the hospital in this case with Ms. Vaught settled it exceedingly early and had the confidentiality provision in place, which was enforceable. And that's why there was the initial press when they were talking to the Sun didn't talk about the case that much, and to my understanding hasn't talked about it since. So we are at a little bit over the 50-minute point. I know that there's some questions that have come in. I would encourage you to keep the questions coming, and we'll get through all of them. And before I leave, if some of you may be jumping off soon while we're doing Q&A, if you have any questions after the fact or would need my help and guidance on similar issues in the future, my information is in the materials. Please do not hesitate to call or email me. I'll be happy to give further assistance. And with that, I will turn the call over to Kelly to help us administer the Q&A portion.
Thanks, Matt. That concludes the slide presentation portion of the program. We would like to begin the question and answer period. If you have questions, please type them in the Q&A box found at the bottom of your screen. Please hover at the bottom. You will see 3 dots. Click on those dots to open the Q&A panel and direct your questions to all panelists. We will try to answer as many questions as we can. And one of the first things that came in is, it might be more speculative, but an individual typed that they were curious why the hospital felt the need to report the death to the medical examiner. Was there something else in the history of the patient beyond the medication error that prompted that notification?
You know, that's a great question, but it's one that I can't answer. As I said, this was very tight-lipped and very unusual in early on the level. Well, not unusual, they were bad facts. There's not much that is known. What is not known is that issue. What is not known why the Department of Health initially cleared Vaught. What is not known is why the physicians put cause of death bleed as opposed to medication error. So there's a lot we don't know about. And again, not being a part of this at all, I can only speculate what was going on in their minds. I can probably assure you that if this criminal trial does go forward, that will probably be revealed. And I will be watching intently. And if there is a criminal trial, I will be sure to follow up this presentation with what we've learned. And if there are any other takeaways moving forward. So I'm sorry I can't answer anything further in that regard. I'd be guessing.
Sure. The next one is, does the hospital bear responsibility for allowing a paralyzing agent to be easily obtained by anyone by just using a simple override?
I think that would be a very easy argument in a civil case or in a criminal case to advance that argument and let the jury decide. I would say that in Pennsylvania under Thompson versus Nason, the corporate negligence, that is a valid criticism. And again, if they use using RaDonda Vaught's own words in the criminal investigation, this is common for overrides, and she did it quite quickly. She knew how to do it. We presume she did it before. And with corporate negligence in Pennsylvania and other jurisdictions that have that, The issue is, that whole concept is to keep the hospital as safe as possible. And the issue would be whether the hospital knew about it or should have known about it, or if they did have policies on it and if those policies were not enforced. Obviously, with the benefit of retrospect, like so many of these cases, they will have someone who say, this was common. You knew about it, and look what, and you knew about it. You didn't do anything about it, and look what we have here. And they're going to use this case as the perfect example. So yes, a jury can attribute liability to the hospital for making the override function. That's simple.
Thank you. And kind of in line with that, do you know if there was anything documented as far as, was there a requirement for a second signature in the medication system to override that paralytic?
There was, as far as I know, that was not the process at the time. But as we went through the Patient Safety Authority report on the errors on health information technology, that is a recommendation. And one of the things we have to be careful about is, with negligence, plaintiffs have to prove duty and the breach of the duty. And if it's out there that these second signatures are needed and they're not, there can be an argument that if you don't have that you've violated a duty because people are advocating it. So you have to be careful about that. And but here's the thing about workarounds. If people are in a crunch, they'll have someone a second signature. Not all the time. It'll probably prevent most of the issues, but they'll figure out a way to get around it. It's just human nature. But anyway, there was not one then. It's recommended you do have one from the Patient Safety Authority article.
Thank you. And kind of reaching back to the criminal charges, would individual liability insurance cover those criminal charges?
There's two parts of insurance. Well, first of all, there's no criminal insurance. If someone's been criminally charged, no insurance can pay for it. You have to pay it out of your back pocket, or have the criminal lawyer do it, without charging, or people, like we have the GoFundMe page set up for her so she can pay her lawyer. In the civil context, there are two important parts of insurance. There's the duty to defend, and there's the duty to indemnify. The duty to defend is the insurance carrier's duty to pay for a lawyer to defend the charges or the allegations of negligence. It's quite typical. Insurance can defend the care, but with a reservation of rights, the carrier can say, we will defend, but we will not indemnify, which means we will not pay any judgment or settlement for this activity. So most likely what would happen is there'd be a defense of the claim, but there wouldn't be any insurance money associated with that on the civil side.
Thank you. And kind of in line with the criminal charges, do you know of anyone else that is facing charges? Somebody was concerned about maybe the neurologist or the NP that were involved in the patient's treatment, I think once returning to the unit. Has anyone else been named?
Not that I'm aware of.
And also, does Tennessee have a patient safety reporting system like Pennsylvania?
I do not believe there are very few states that have something similar to PACERS. I believe the Tennessee system is just based like on our normal Department of Health one. That's where there was some scrutiny as why it wasn't reported. It should have been. There's been some scrutiny on that. But I am not a Tennessee healthcare lawyer, but there was considerable scrutiny as to why this was not reported and should it have been.
I think we might have time for maybe one more question. We are coming down to the close of the hour. How can hospitals motivate EHR companies to design with regard to human factors and lean workflows to reduce the need for workarounds? And that's certainly a lot of what we were hearing in this case.
That's a great question to end on, and I'll get into that answer right now. But before I go, for those of you who have questions that have not been answered, again, email me or call me. I'll be happy to answer if we didn't get to them today. I know we're up on time. I think this requires a fundamental change in how we deal with our vendors on these systems. I think one of the overlying criticisms you will see from clinicians about these systems is that they're not designed for them. They're designed for billing and processing claims, and that they're not easy, and it is contributing to, look, we have the situation here where someone's individual liberties are at stake, and you have physician burnout, and you have hiring of scribes. This is not what we had in mind with electronic medical records when we pushed for this more than a decade ago. And it is, to my mind, it is. I've always questioned how on earth did people create these systems. They seem to be designed more so for IT or by IT, with an IT mentality than clinical mentality. We can go on and on about the other issues associated with electronic medical records. I think that there has to be I don't know how you develop a better relationship with the vendors, but when there are negotiations going on, when you're shopping around or talking with modifying your system, there has to be a greater emphasis on clinician understanding and workflow on this. I think that if you would poll your staff, I would say 9 out of 10 people would agree with that. And why we haven't, I don't know. I'm not in that position to talk of that. But I think it's certainly something we should be doing. And you can use these materials as case in point. That because there's so many of these pop-ups, this person, whether she was wrong or right, she blew through 5 ones that to a normal person would seem inexcusable. And she would go through the 5 EMR pop-up warnings and go through all those red flags that were talked about. But in that environment where there's so many things and there's so many of patients and there's a need to get the medications out quicker, and that the inability for the electronic medical record and the MAR to integrate, where people are double documenting or double doing everything, it adds up, and they need to be aware of that. They should maybe they should be on this call. Maybe you should ask them to be on these calls or to be aware of these types of things. But obviously, there has to be a better job in relating clinical concerns about the electronic medical records with the people who create these things.
Thank you so much. It's a lot of information, I think, for all of us to digest, whether you've heard this scenario for the first time or have heard it before, and this is providing additional information. I know I would just like to add that there is the CMS findings from their survey with that facility. It is available and online. I can't remember exactly where, but I know I've read that. I know there's more questions that pertain to the specifics that were going on in the facility. You might find your answers there. And since we are out of time, I want to thank everyone again for joining us today. This concludes our webinar. Thank you.